A very major decision came down from the Northern District of Illinois, which is the federal court in the Chicago area, in a case called Carbone versus Brown University. The allegations were that the defendants, which included MIT, Yale, Caltech, Duke, were members of something called the 568 Presidents Group. 568 is an antitrust exemption that allows universities and colleges to work together to establish what they define as a needs-based profile, as long as all of the members of the association admit students strictly without a view to need. And there was a motion to dismiss that was filed by these universities saying that the case really shouldn't go forward. That motion to dismiss was denied. And in fact, the plaintiffs had a couple of arguments that were persuasive to the federal court. First, they argued that a number of the institutions involved had selectively admitted people who had parents or grandparents or relatives who had been donors in the past or had previously attended the school. So it wasn't strictly need blind. They also argued that a number of the universities had a secretive program where, when they were determining who to let in off the wait list and how to manage the offers that they gave, that they considered a number of factors, including whether or not those students would require financial aid. If in fact this case does go forward, the consequences to these major institutions could be very, very serious. As we know, there have been prior lawsuits challenging the admissions practices at Harvard and other institutions, including Berkeley Law. And as discovery progresses, the dirty laundry of how people are really admitted will come forth. And one of the arguments is that ultimately they're going to prove that as you get down towards the people that are barely admitted, that you go back and take a look at people that are close to being admitted and go evaluate whether they have a likelihood of contributing and making donations to the university, or their family does. And in fact, this particular practice was certainly at issue in the pay-to-play scandals involving USC and other institutions. This case, if you want to see who the greatest law firms are in the United States of America, has what can only be called an absolute all-star lineup: Arnold Porter, Kay Schuller, Skadden Arps. Any firm that's involved in defending this case, defending Dartmouth, defending Yale, and so on and so forth, is absolutely cream of the crop. As a matter of fact, there's a pretty good argument that if the firm is not involved in defending one of the Ivy League institutions, that it most certainly at some level is second tier.